meeting of the Foster Care and Adoption Task Force to order. And we do have a quorum. Legal counsel and I have spent the last couple of minutes just doing a count. We have 13 present, and so that exceeds the number that we actually need for our quorum. I would like to say from the outset that we do have Chairman Wiggins, who's participating via Zoom. There he is. And then we also have other members of our committee who are participating as well. I see Mrs. Himes, Mr. Calder. I can't see on the other end. Hold on a minute, because I want to make sure I announce everybody who's here. Judge Dickinson and Mrs. Baumgarter. So thank y'all for participating via Zoom this afternoon. You should have before you in your packet, and hopefully it's being emailed to the task force members who are participating via Zoom, a copy of the draft minutes and also the agenda for today. So if you don't have it, let us know. So we'll make sure that you get it before the start of the meeting. And for those who are physically here in the room with us, you should have before you a draft copy of the minutes as well as today's agenda. And so I'm going to give you just a few minutes to peruse the minutes and review those before I entertain a motion, just to see, make sure you've had a chance to read them or review them. Let me know if you have any amendments and or corrections.
I received the agenda, but I don't think that I have received the minutes.
Okay, could we please email Judge Dickinson the minutes, please? Judge Dickinson, we're about to get those emailed to you.
Thank you.
You're welcome. Is there anyone else who needs the minutes?
Yes, you would for Dana report.
We'll get those emailed to you as well.
I'll send it in as well.
Okay.
David Calder as well.
So everyone, we've got it taken care of. I see that Ms. Trials gave me the thumbs up, so we're getting it taken care of. What I'm going to do, so that for purposes of those task force members who are on Zoom, I want to make sure that you have an opportunity to review those minutes and that you have them before we actually vote on them. So we're going to go to the next item on our agenda, which would be Justice Beam with the report for subcommittee number 1. That'll give us time to get you the minutes. And so, Justice Beam, are you ready? And you should have a copy of subcommittee number 1's report also in your packet. If you don't, please let us know, and either Ms. Pat or Ms. Cassie will get you a copy. All right, Justice Beam.
Our committee was charged with 4 different responsibilities, and you have a report from us with that 2 times. It may look like I'm by myself, but I have several people that are on Zoom that have my back.
Sorry, we can't hear on Zoom.
Can you hear now?
What about now, Justice Dickerson? Can you hear? Mr. Calder, can you hear?
No.
You know, when you turn it on, it's a miracle. You can hear now, right? I'm a back it up a little bit. Sounded like I had my mama's voice on there. Okay. Since I heard that y'all didn't hear it on Zoom, I'm going to say it again, that I may look like I'm by myself, but I got backup on Zoom. Our committee has met twice, and just want to give a shout out to our members. Dana Baumgartner is on the Zoom in the right-hand corner, and Samina Taylor, is she on? She is coming by Zoom, but she's not on yet.
He's not on yet.
Jamie Hines is on, and she's going to present the last 2 issues for us. And then Hadley Gable with the AG's office. she has not attended our meetings, and so I'm not quite sure why, but we'll try to reach out to her. As I said, we met twice, August the 2nd, and then we also met a week ago, Monday. And I'm just going to start with the first challenge, and then we'll talk about it, and I'll stop at the end of each, and then we can discuss it if people have other input in that, because we want to make the right recommendation. So the first one is review of timeframes and guidelines followed once a child comes in Child Protection Services custody, and how to balance the length of those timeframes, the best interest of the child, and the interest of the biological parents. Now, I had the cutest little PowerPoint with cute little pictures and stuff, but I'm computer challenged, and that's in Hattiesburg. Okay, so it's not here today. So just imagine the cutest little PowerPoint that set forth these questions. But we talked about that removals. Hey, you know what occurs to me? Does Zoom have our report?
Yes,
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 okay,
Justice
right.
Green, they do.
Just making sure. Removals are reviewed at shelter hearings held within 48 hours of removal, not including holidays and weekends. This is just setting forth what the timeframes are if you don't know what those timeframes are. Folks that deal with this every day are oh so familiar. If a child is maintained in a shelter, then an adjudication must occur within 30 days. And then Mississippi law requires permanency hearings within 6 months of removal compared to a 1-year federal requirement. And then some recommendations that we talked about is consider reviewing hearings every 30 days for children under the age of 3. If you're a parent, then you know how important those formative 3 years are. And those judges that are in county courts or larger counties, some have already implemented that. I know before Judge Broom died, his court did that. He suggested I do it, so before I came to the court, I did that. And I know some judges do that because it's accountability to try to help reunify that mother or father as quickly as possible from age 1 to 3 because of how important that time is. Permanency hearings more often than 6 months, perhaps 90 days. If you don't have a permanency hearing for 6 months, you go to a shelter hearing, and that is just too much time. You know, when we talk about court time, we're talking about accountability. It's accountability for the parent, it's accountability for CPS, and everyone involved in the court. So if we were able to have court times more frequently, then the hope is either the parent would complete their service agreement and be able to be reunified with the child, or that would quickly let us know who's serious about being a parent and who's not. And so we talked about how important that was to get in court as quickly as possible. The need for more resources in smaller counties. Dana is from Wayne County, and they don't have the same resources that are in Hinds County. And so when we talk about the law and that reasonable efforts need to be provided to help a parent to meet that service agreement, then we have to recognize that in some of our counties, there's that are not the resources that are needed in order for that parent. Technology to connect needs with resources to help parents complete service agreements. In the legislative session, this past session, when they set up this committee, they also charged the Attorney General with looking at this technology. This could be a huge game changer, not just with youth court, but with trying to keep kids out of ever being called. If we could have counselors that had access to this technology that could get those resources in that home, then they would never have to make that call to the hotline for neglect. When we know that 68% of our kids are taken into custody because of neglect, and oftentimes in a state with the highest level of poverty we need to rethink the way we look at the challenges that kids face and try to think of how we can leave that child in the home and bring those services to them. I also say no parent should ever lose their child because they're just not poor, because they're poor. That just shouldn't happen in our state. But I'm afraid that I have seen the resources not be there, and we need to do better. We owe it to our kids to do better. We know they want their parents. So that technology is just a huge thing, and I look forward to talking to the Attorney General and the Commissioner of CPS next week about that. That's something that we in the Children's Justice Commission have pushed for some time. The final thought was to expand county court and regional courts to allow for full-time judges, and staff will allow more court times and hopefully shorter time periods in custody. I was just left an access to justice meeting over at the Supreme Court, and I heard a lawyer say that youth court referees is a huge obligation, and we don't pay our youth court referees probably for the time adequately that they spend doing it. But if we had regional county courts, that means in Hinds County we already have a county court, Forest County, Lamar County have county courts, but in Perry County and some of the other smaller counties in our state, if we could connect several counties together, that would allow for more court time, because lawyers wouldn't be pulled away with other scheduled court. And also with court staff, they can push those court dates. I talked about court dates and accountability for everybody. And if we were all going before the court on a regular basis, if mom was not getting the resources she needed, we could make sure that was happening. If the child is not getting the resources they need, whether that be medical or education or whatever, we just want to make sure that we are doing everything we can to provide safety for kids, but at the same time, move them to permanency as quickly as possible. And with that, Representative Cockerham, I would stop and see what input we might have on that first issue, other than what we've recommended.
Thank you, Justice Beam, for presenting the first issue. Are there any comments, questions, concerns of Justice Beam on the first issue? I don't see any. I did have two questions.
I did this, Bryce.
Oh, I didn't see you. Okay, go ahead, Bryce.
I was late. Justice Beam, I first want to say I appreciate everything you do for our kids and things like this, so thank you. My question is on the regional courts you mentioned. It invariably, whenever such things get discussed, people come out of the woodwork and immediately raise opposition for various reasons. And my assessment is usually it's not anything having to do with the children. So when y'all were looking at it, did you consider the opposition, or what were the, negatives to that, or doing such things? And you mentioned the referees, and we don't pay them, and I agree with that, probably certainly what they do in terms of work. But the trade-off is if you go to a regional court, I would assume that it becomes a full-time thing. So did y'all have those discussions?
No, sir, Senator Wiggins, we were dreaming. We were dreaming about how we could better serve Mississippi, and just the need for more frequent courts. That would be for others to discuss, but I think we need to, in the mix, talk about the needs of families and the importance of more frequent court time in that.
So just to clarify, y'all are recommending the regional courts as a way to have more frequent court appearances because, according to y'all, we don't have enough to get them through the system.
When a child is under the age of 3 and their parent only goes to court every 6 months, that is just not appropriate. And we've got mental health folks on this task force that can certainly speak to that. But just as a mother, it's just common sense that they need more court time.
Gotcha, thank you.
Justice Beam, one of your possible recommendations was the need for more resources in smaller counties. What resources did the subcommittee envision? Was it financial resources, more personnel?
Well, Dana's kind of, she's gone black over there, and I'm calling out my backup. Dana from Wayne County. She's a guardian ad litem, and she also works some in Jones County. Tell us about the challenges with resources. I think we talked about addiction resources and other resources. Can you kind of speak to that?
Well, particularly in Wayne County, in Jones County, it's the parents typically have access to lots of free resources for, just thinking about addiction to 12-step meetings and different programs and stuff. But in Wayne County, a lot of times, as we've touched on, we're dealing with kind of abject poverty. It's really, the people really do not have funds, and they may want to get better, but they can't afford to travel 3, 4, 7 times a week to Laurel to go attend some of these meetings. And so I don't know what the answer is on that one in particular, but that's a need that we have that we're exploring. Other things, it was kind of sad to me that I learned about a resource during one of our meetings that we likely could have already been trying to utilize, but the knowledge just wasn't out there. And so, we just did not know about it. And so I think that may kind of tie in with the technology. I mean, we can have some sort of uniform list of the things that are available, maybe some bullet points on some things that they help with. That would be helpful as well.
Okay, thank you. And then Justice Beam, with respect to expansion of the county court to regional courts, there's been a lot of concern and discussion about this in my area, particularly Southwest Mississippi, where it's very rural, and there has been some concern expressed to me with regard to the Delta, where it's very rural as well and very spread out. Did your subcommittee give any thought to conceptually what these courts may look like?
No, Representative Cockerham. We simply were focusing on the best interest of the child. That was the challenge that to us is looking at the time frames and balancing the best interest of the child and the interest of the biological parents. And so any discussion of size of counties and those things, that was not on our radar. We simply acknowledged that if people were in court more often, we could make sure they had the resources in order to complete those service plans. And to me, that's the goal of youth court.
And then what about also, just a follow-up question, particularly with respect to rural counties, but I guess it could apply to any county for parents who have to travel long distances if there's a regional court. For instance, I would expect probably here in central Mississippi and on the coast, it may be a little bit of a shorter distance to travel with respect between counties. And so was there any consideration given to whether a parent would possibly may not be able to attend the court as needed or as frequently just because of the distance?
I think one thing that we all need to acknowledge is if people are lacking resources, then transportation is probably at the top of the list. And certainly as a former chancellor, it was nothing for us to ride the circuit from one county to another. So I think that as the legislature looks at what the needs of Mississippi are, transportation needs to be at the top. But this is one thing that I would point out to you, is that a child in Rolling Fork should not be forced to stay in foster care longer just because they live in Rolling Fork and not Hinds County. And so that's the kind of thought process that we need to have. We're talking about the best interest of each child, and each child stands on their own. They have feelings and needs, and so that's just something that we need to think about. We need resources in smaller counties, and we know that medical services, pediatricians may not be available. We just need to look at that and see how better we can serve these rural counties.
Thank you, Justice Beam. Judge Crystal Wise Martin is recognized.
I wanted to know, Justice Dean, whether the use of technology was considered by the committee implementing some of the recommendations.
Whether technology was considered by the committee in the recommendation, is that what you asked?
Yes. He said yes.
Yes.
We help alleviate some of the other, thank you so much.
You would think we know how to use microphones by now.
Well, I got my hearing aids on, but I'm sorry, I didn't totally understand you. Go ahead.
Yes, you essentially heard my question, which was, did your committee or subcommittee consider the use of technology in implementing some of the recommendations the committee is making? And if not, do you think technology will assist in achieving some of the goals?
Let's just talk about what our service plans look like, okay? Get a place to live, get a job, get mental health services. And when we think about CPS, they're not a employment service, they're not a housing service, they're not a food pantry. And so if we had technology that could help a parent complete their service plan faster, bam, because once they satisfy that they have a safe environment to live, they meet the requirements to return that child home. So when we lack resources, and if it was, I had a wonderful mother and have a wonderful dad, and if the ox got in the ditch, I would call my mother and daddy and get out of the ditch, right? And I know your mama would get you out of the ditch because I know her. But think
My dad
about
would
it.
be there first, though.
When we have generational poverty, there's nobody to call to get the ox out of the ditch. They're looking at us. And so that's why technology is so important, is because we want to make sure that whether it's CPS sitting looking at that person or the parent rep saying, you got to have housing, well, here's how you get it, or whoever, DHS, whoever's looking at that person, that they can connect these resources. Nobody has just a drug problem. They have a drug problem, housing problem, mental health problem, probably lots of things. So I can't understate the importance of that. And I can hardly operate my cell phone, so I'm not saying that I can do anything other than dream.
May I?
Proceed, yes.
I'm sorry, I don't want to interrupt. Listen, I have a couple comments and questions whenever the time's right.
I believe Judge Wise Martin still had some other questions remaining, did you not?
Well, I was just going to piggyback on what you were saying, particularly when it came to increasing the number of updates review hearings to every 30 days. I know sometimes people have difficulty traveling, as we were discussing, to court, and I guess with the use of, for instance, Zoom, technology assists people in being able to adhere to the more frequent review hearings, things of that nature.
We're here to serve the people that are in our court, so certainly we need to think out of the box on that. I remember talking to Dr. Wright before she left the Department of Education and how they had put computers in all the homes of children, and why not use that technology? So you're right, and I know that judges want to do the right thing, and so things like that certainly need to be looked at.
And I also think about the issue as it comes to telehealth. Now we're having more and more medical visits via telehealth rather than in person. So that might also be an option with the mental health updates and things of that nature.
We're going to address that shortly, some opportunities that we're looking at for mental health. Jamie is our resident expert on mental health issues, so we're going to talk about thinking outside the box on that.
Thank you.
Okay, Judge,
Judge Dickinson, you're recognized.
Thank you, Madam Chairman. Just a couple of comments. Justice Beam, I couldn't agree with you more on the permanency hearings and more frequent permanency hearings. I have noticed in my court, and I do this every day of the week, that the more often that I see these families, the more likely that they're going to reach reunification or the kids are going to reach permanency in some form, fashion, because my entire team is aware of what's going on. So I completely agree with more often, having permanency more often. I'm not sure all of my colleagues will agree with me, but I think it's something, you're talking about the best interest of children, that is absolutely something that's key. The other couple of things I was wondering about, the research and the experts in terms of everything I've reviewed, all the literature, all the conferences I've been to, suggest that high-quality family time or visitation time is something that is crucial to reunifying parents with their kids more quickly. And as I understand the current CDS policy regarding visitation, it provides for a minimum of 2 hours per month visitation between the children and their parents. Now, in my humble opinion, that is not nearly enough. And I was wondering if your subcommittee discussed the possibility of maybe changing or requiring a change in the visitation policy to make visitation more frequently. And I understand that there are the flip side of that is the resources available and the caseworkers available at CPS to conduct those visitations. So that's the first question. And the second question that I had piggybacks off of something that the Deputy Commissioner brought up at the first task force meeting, and that was the fact that these cases, when they come in on the protection side, and a child goes into custody, they go to one judge, and then if the case goes down the track of TPR, based on in county court, we have a full-time county court judge, they stay with that judge, but they don't do that for the referee court. And then once TPR is accomplished, then under the current state of the law, whether it's a county court or a referee court, it's going to go to a chancellor for the adoption. And I was wondering if your subcommittee gave any thought to making the recommendation that these kids get followed from beginning to end by one judge. I believe that's in the best interest of these children to not, at the end of the case, send the kid to another judge who has no knowledge of the case or the history of the family to make the ultimate determination of permanency for the child. So those are my two questions. The other comments that I just wanted to touch on quickly relate to technology. I can tell you when COVID hit, my court immediately went to Zoom. We didn't skip a beat. We went to Zoom hearings and have found it wildly successful because we have people. I'm situated in the southeastern corner of our county where my court is. And I've got a lot of folks that serve on the west side of the county, north part of the county, that have transportation problems. And transportation is absolutely a very real problem. But Zoom has helped us eliminate that barrier. And I will tell you too that we got a grant a couple of years ago. One of the things, obviously, the barriers that we identified was transportation. And so we purchased a van and have been able to eliminate some of that barrier via technology, the Zoom capability, and the van. So I just wanted to make those comments and ask those questions.
Judge Dickinson, you've done a fabulous job in Harrison County in reducing the number of kids in foster care, and certainly you raise a lot of important points. Visitation, I noticed our Deputy Commissioner sitting here shaking his head, and that's a policy consideration that also has to do with manpower, but certainly, my thought is if we could get our kids that need to go home out of foster care quicker, then that would allow your folks to spend more time on cases that really need your attention. And So that's one thought. Also, Judge Dickinson, I think I extended visitation myself beyond that, and certainly that's one thing that judges have the ability to do. With regard to the same judge, my understanding and county court and all of that, that was on somebody else's list of to-dos and not our committees, but your point is well taken. And then with regard to Zoom, I just wrote that down as adding that because I think that's very important. When we acknowledge that transportation is so difficult for our folks to get to a service provider to even meet the service agreement, then we shouldn't be putting up obstacles. We should be trying to do everything we can to help. So I've added that to our list if that's okay with our committee.
Mrs. Wilder is recognized.
Morgan.
Mrs. Morgan, pardon me, Mrs. Morgan.
You're fine. Judge Dickinson brings up a great point about most kids get 24 hours a year with their parents in visitation. But what we are seeing a lot is that visitation defaults to supervised visitation. And especially when you've got 68% of the kids coming in for unintentional neglect or poverty reasons, there's no need for CPS to spend that manpower to default to supervised visitation when there's no risk of harm to the child. So I think that would help alleviate some of the physical and manpower concerns if we don't default to supervised visitation.
That and also relative placement is so important, I would say, too, when you talk about visitation, making sure that we're doing reasonable efforts to try to put the child in the home of a family member, someone.
Mrs. Lindsay Simmons is recognized. I can't hear you very well.
I can't either.
Right there. I don't ever get to sit in these seats, y'all know. I'm on this committee from a foster parent standpoint, and so I think all of this is wonderful, and I'm hearing the suggestions. And what I would like to say is, I think it's very difficult when the plan for every child is reunification, and the timeline is the same, and the visitations are the same. For us, my kids were from Hancock County. I'm in Rankin, and I was licensed through Jamie at Southern Christian. I had 6 social workers assigned to me. And if I had had to make multiple trips to Hancock County a month, I would have lost my mind. And in some cases, reunification is not in the best interest of the child. And when you're forcing those children into those visits 2 and 3 times a month, it is extremely disruptive to that child and that adoptive family. And so I just think it doesn't always have to be this black and white timeline, but if judges could have more discretion, that would be great. And if a judge thinks this mom is on the right track, let's let them have more visits, that's fantastic. And if the mom is not on the right track, don't do that to those children of that foster family. So I just think it would help to have more flexibility, and I don't even know if that's a thing. But that's just my opinion as a foster parent.
Actually, all plans, family service plans, are to be individualized to that family. So to hear you say that it was cookie cutter is part of the problem.
It is, because they're not. And I think there are a lot of good intentions, and then things are you're forced into this cookie cutter box. So,
Hats off to all foster parents that step up and open their home and their heart to children. A couple of thoughts. One is we need more foster families. We need more therapeutic foster families. A child should not be in Rankin County when their mom and daddy are in Hancock County. And we're going to talk about some mental health challenges in a minute that are even more challenging to try to get that child back on its feet, his or her feet. And so what I would say is if we could determine whether or not termination is going to, by having more frequent court dates, understanding that parents, what their position is, are they going to be parents or do they just not want to? I think we could move families to permanency. I know it's so hurtful after a child has been in a home for a year and then you return that child. Let's do everything we can to give these parents a chance, and if not, let's move them to permanency faster. And also, we need more foster parents. Make sure that you tell the commissioner, I keep plugging that, more foster parents, more foster parents.
If I could, this is Allison McMinn on Zoom. Can you guys hear me okay?
Yes, we can.
Just a minor point here, just to kind of dovetail with what Vince was just saying. As a former foster parent, with respect to visitation, I do agree with Justice Benning and Judge Dickinson that more visits, when the plan is communication, more visits with the parent are key, because I think it motivates the parents and it keeps that connection with the children. However, as a working parent, foster parent, I worked in downtown Jackson. My husband worked out on the reservoir. The children were from Yazoo City, and the social worker required us every other week to drive to Yazoo City at 2 o'clock. So I had to take off half a day of work, and my husband did too, usually, every other week to maintain that visitation. It was an incredible hardship. I mean, I'm an attorney. I have to bill hours. It was just very, very difficult to maintain those visits, and our social worker would not come and pick up the children. So it was just very, very difficult. And we maintained the visits. We didn't miss a visit. They had a grandmother that never missed a visit. I mean, they were important. I don't regret it at all. I'm glad we're able to maintain it. But if you're looking to get more foster parents, that is certainly not the way to do it. Because we just were lucky that we had flexible jobs that were able to take off. I mean, the children were at daycare and in school. And by 2:30, they would be home. So I had to make 2 stops after leaving Jackson to pick them up and then drive them 45 minutes to Yazoo City.
Certainly.
And, you know, we're never reimbursed for gas or anything like that, which is fine, but that is definitely to be taken into consideration as the hardship on the foster parent and required visitation during the day in another county with children who are in multiple different locations who have working parents.
Certainly, our hats are off to foster parents for the sacrifice that they make. I would say that it's important that we have foster families in every county so that children are not uprooted from their school, so that they can have meaningful visitation. And, you know, it's great for that foster family to be with that biological family. The best case is for that foster family to keep on with that relationship and cheer that parent on. That can be some of the most rewarding experiences. So I know the headache of travel, and it's a sacrifice that everybody makes, and we appreciate that.
Of course, and I certainly wasn't saying that just to complain, as a matter of point to say we need to try to live like a social worker should come and keep the children and take them to the business. I mean, I'm happy to maintain the business. I mean, I really wanted to get to know the biological family, and we did, and I was happy to get to know them. But it's just that it was such a hardship. If you want more foster families, there's going to have to be some give and take there with the social worker. Someone is going to have to, you know, come and pick up the children if they're in different counties. I had no problem with that. She just wouldn't do it.
Are there any other questions or comments? Seeing none, Justice Beam, if you wanted to, I'm sorry, Mrs. Himes.
Yes, thank you. I just want to piggyback
Thank you.
On what Allison said. If we can find a rank system, and I do believe we can, to encourage more organizations like Southern Christian to get involved in non-therapeutic foster care, we can help with the transportation and the supportive services that go along supporting the foster families. That's a longer conversation, everything happen another time, but I don't think that our private providers or private non-profit providers are being used to their full capacity.
Are you ready for the next point?
I am. If there are no, I want to make sure before you proceed that there aren't any other questions. Okay, seeing none, wait a minute, I do have one. With the visits that you mentioned, are they occurring in neutral locations? Are they occurring at the natural parent's home? Where do the visits typically take place?
You want me to answer?
CPS office.
Yeah. CPS office or a public place, like a restaurant or a park or something like that.
Okay, all right, thank you.
In Harrison County, we have established a visitation center, and it allows CPS or foster parents who are available to drop off the kids. We have people on staff who are trained, they've been through supervised visitation training, and they're trained to supervise visits, and through that, it allows, for instance, if we have a parent that has a day off, and they have the ability to spend half a day or a whole day with their child, they can use that visitation center and spend way more than, 2 hours a month. So that's one of the things we've done down here.
Okay, all right, very good, thank you.
Angela, this is Bryce, I'm sorry, I have one question for Lindsay. Lindsay Simmons. Lindsay, did you say you had 6 workers assigned to you? Is that right? And if that's the case, why 6?
I did, and I will say, I had wonderful social workers. So I have heard horror stories, and I don't have any of those. So I'm thankful for that. But my kid's county of origin was Hancock, and so I had a social worker and an adoption specialist from there. We were in Rankin and had a social worker and an adoption specialist, and then I was with Southern Christian Services with a social worker and adoption specialist. And we had a rule in our house that everyone could come on Friday afternoons because they tried to come all during the week at all different times and see my kids at school and all that. And I just said, we took off every Friday afternoon, and y'all can all 6 come if you want to. The Hancock ones came infrequently, so that wasn't a big deal. Southern Christian were our main primary ones, and they were fantastic, and they ran a lot of interference for us, and we would see them, and they would communicate with CPS, but then we did have to see the Rankin County ones as well. So it was a lot on top of school and all the required appointments and therapy and all the things.
TBRI, which is trust-based relational intervention. And we want to be able to teach that to our biological parents as well as our foster parents, but we want to do those things in-house if we can, and utilize our staff as much as possible. So we have the one person that is what we call our family care coordinator, who is the full-time person. The other 2 individuals, one is Tiffany, and she is actually my family intervention coordinator. So she has a lot of other job duties, but she went through that training, and if necessary, she can absolutely supervise visits. And then we have our case managers. They can go through training, but they work with our families routinely in family intervention. And so it's staff members, 2 staff members that have other jobs within the youth court, but who are trained to supervise visits, and then the one person who is basically dedicated to supervising. She has other duties, but she's basically dedicated to supervising visits. And what we did is we had a children's shelter down here since I believe the 60s. And when the numbers started coming down in Harrison County, we didn't have a need to put kids in shelter. And we also at the same time had a big boost in foster homes. And so the number of kids that were spending the night in the shelter went way down, so we converted it into supervised visitation centers. And the board of supervisors decided that they wanted to go ahead and close it, so they closed our shelter. But right down the street, we had 2 trailers, they're just mobile home trailers, that we renovated and made into a very home-like, very warm setting. There are 4 visitation rooms, and there are 2 kind of main open areas, one of which we have an Xbox, and for those older kids that they like to play video games with their dad, they can go and do that there. But we have them separated by age groups, so 4 different rooms. And so we can, theoretically, we can run in that center easily 6 different visitations at once. We also have down the street an outdoor playground that is utilized for visitation. So right now it's what it looks like.
Oh, it does. Yes, it does. Very descriptive. Thank you. Are there any further questions regarding issue number 1?
If I could just ask, Judge Dickinson, what is the percentage decrease of kids in custody since you've been there?
It is almost right at 75%. I think 74.6 or something. When I started, we had 792 kids in custody. That fluctuated between 800 and 1,000 before I got here at any given time. And the last report I saw, I want to say it was 211, maybe 220. It still fluctuates, but it is significantly decreased. And that is through implementation of best practices and standards. I think I mentioned it in our first meeting, but I came to this world of child welfare a blank slate. I was a foster dad, and that's about all I knew. And so the ability to absorb the things, the best practices and standards that Mississippi Judicial College instilled in us, as well as all the trainings across the country that I've been to, this is the result of the implementation of best practices and standards.
So when we talk about number 1, when you have frequent court time, when you have resources available, I say everybody's not called to be a foster parent, but everybody's called to be something. Harrison County woke up and their community embraced this, and that's really the key to decreasing the time frames in 1. If it's okay with you, I'm going to go to number 2.
Please.
Okay. Review the requirements to have concurrent permanency plans, whether this is currently taking place, and if so, whether it is effective, and if not effective, what needs to happen to ensure the courts and Child Protective Services are pursuing concurrent plans. This is a requirement of federal regulations. The purpose of it is to hasten permanency. It should be happening in all jurisdictions, but a great deal of emphasis is placed on the first plan, which is often reunification with less emphasis on the alternative. More training would be helpful with all involved to drive home the importance. All court personnel have been trained in this area, and the court's My Kids data and court filing system help drive all hearing dates to meet the requirements and setting forth concurrent plans. When we talked about this, concurrent plans were expressed, a concern was expressed about My Kids and notice requirements to parties and youth. That is something that we need to communicate with My Kids, and I will do that to make sure that we have notice requirements. We have a new youth requirement of notice, and so we want to make sure that we're doing all of that. We also need better communication with provider side on concurrent plan. Jamie mentioned that our service providers don't always know what that current plan is, and so we need to do a better job that everybody knows and is on the same plan, that we have 2 plans. One is oftentimes reunification, but if that falls through, then we don't want to start all over again. We want to move that child to permanency as quickly as possible. We also, when you talk about concurrent plans, that oftentimes is driven by the court order that has both of those in there, and that's federally mandated. And so if we had full-time staff to help generate those orders, that would be so much more helpful, and also more frequent time helps with those concurrent plans. So that's when you talk about how regional courts for these smaller counties it would be more advantageous. When we have county courts with full-time staff and full-time judges, then we're able to have the orders oftentimes completed right there on the spot. Everybody knows what the plan is, and they leave with their marching orders. When time lags because of resources for orders to be prepared, then we don't have that same push for concurrent. And I think there has to be a change in our mindset. We've been going for years from a crisis mode of, oh my gosh, let's do what we can to help the parent. And as we have resources available for those parents and are doing all we can to help that parent, we can also be thinking ahead to that concurrent plan. And so that's just important for everybody in that courtroom to do. So that is number 2, concurrent planning. And the recommendation would be to improve my kids, to make sure that there's better communication with regard to what the plan is. And then finally, if we had full-time staffing of the court through regional, that would allow for more court times and personnel to make sure that everybody knows the concurrent plan.
Is there a problem now with everyone knowing what the concurrent plan is?
Well, as a lawyer, we are in court and we know the judge is saying, okay, I'm ruling that so-and-so and so-and-so, and the concurrent plan is so-and-so. But oftentimes, people are just, anxious about being in court, and it's just something about having that in black and white that they can take home. And it's a carrot and a stick. It's great for a parent to know that if you don't get your act together, we're going to have to do something else. So I would say that the problem is that it is important that be reduced to writing, and that everybody that's on that is working in that case, the parent rep, everybody needs to understand what that is. And when we don't have it reduced to writing in a timely manner, that's a problem.
Proceed.
I would love to say that parents do get a copy of their orders, but the current statute says that parents are not allowed to get copies of their case plan or the court orders. It is considered confidential. They can view it, but they cannot have a copy of it. So I think that's something that we really need to look at statutorily, because most parents, they go into panic mode. And they're like, I just want to see it in writing other than what CPS provides. And the judge is saying, no, I'm not allowed to give you that.
That's 100% true. Just on the practical side of this, I completely agree with Josephine. When these folks are in court, they're nervous. They don't write anything down. In my court, we have a full-time parent rep. I'm a big advocate of that, and it helps so much. But on the practical side of it, at the conclusion of the position, the judge is ordering a permanent plan, typically reunification, and the current plan is either custody to a relative or durable legal custody. And CPS does work that plan. If the child is not placed with a relative, of course, they're exploring relative and victim kin placement. Ideally, that would take place initially right after removal. They would go to a relative, but oftentimes these parents are not going to identify anybody. They don't want it. They have a bad relationship with their family or whatever. But a relative and victim kin placement up front would be ideal. Durable legal custody requires 6 months of placement. So you can arguably, you can say that you make reasonable efforts to achieve durable legal custody as soon as you place a child somewhere, if they're a potential durable legal custodian. But I completely agree, Justice Dean, that it's hard for them to take in everything. And you got to remember, these the people that we serve. In my court, I would say 85 to 90% of them, there's a substance use disorder, and so they're on something. And they're not going to retain information, which is why, again, having a lawyer represent these parents full-time is key, in my opinion. So that's my 2 cents on that.
Were there any other questions or comments?
May I make a statement?
Yes, please.
So yes. reference with Judge Dickinson. It's not always been my experience in Wayne and Jones County, because I go over there privately a little bit when I represent people. I don't, and one of the things that Judge Thompson in Jones County, I sat down and talked to him. I don't think that it's uniform that the concurrent plans are being worked to the extent that they could be. I don't know if that's a localized area to my area or not, but, you know, when I was speaking with Judge Thompson, one of the things that he talked about was how, particularly with substance abuse, people who have problems with substance abuse, they may not even begin working their plan for 6 months because they know they don't have to come to court for 6 months. And so I think particularly with younger children, these two kind of go hand in hand. If we're having more frequent court, we'll know, and I think this has been mentioned, but it ties into this issue as well. So I think we'll know, and CPS can kind of have a heads up for how heavily maybe they need to be pursuing that second option. But it's been my experience as with Judge Thompson as well, when I spoke to him, that typically they get to the 6 month mark, and even if the parent isn't doing anything, you know, the concurrent plan hasn't been worked, so it feels like it's kind of starting all over. So that's just some thoughts.
Thank you.
Okay, with regard to number 3, review of the requirement for psychological assessment or evaluation for each child coming into custody, whether this is necessary in every case, and if so, how to address the major shortage of medical providers that will be able to provide the service. I'll read the result, Jamie, and then we're going to look at you for the solutions, okay? In looking at this, mental health assessments, not psychological assessments, are required for every child within 30 days of coming into care per CPS policy. So the difference, a psychological evaluation requires a doctor, and what we have, most of our children that come in, almost every one of them has some kind of trauma, and so mental health assessments are critical, but we have lots of people that can do that. We find this policy reasonable and responsible. It allows most master level mental health providers, not just psychologists, to complete assessments, which addresses the shortfall of medical providers. We recommend no change to the current policy. Within Mississippi's foster care system, children are classified either therapeutic or non-therapeutic for placement purposes. This classification determines the placement options which agencies are allowed to provide services per diem and foster parent board rates, and whether the child is required to receive mental health counseling. Current CPS protocols require annual psychological assessments to be completed by a PhD-level psychologist to justify a therapeutic classification. There are too few psychologists in Mississippi who accept Medicaid, and those that do have very long wait lines. This creates a backlog of children needing assessment for proper placement. And so, Jamie, if you wouldn't mind speaking to this, Jamie Hines is our MACA representative, and so if you could address that. And we have had lots of input on this area. Go ahead.
Sure. So what we have here is our subcommittee was in agreement with current CPS policy. There's mental health assessments is very different than a psychological. Where the psychologicals come in, like Justice Bean mentioned, is within the protocol of CPS to identify children and youth as therapeutic or non-therapeutic. That can clog the system, leaving a therapeutic child kind of in limbo because they don't have the therapeutic ruling yet. They haven't come to see a psychologist for an assessment. This is a pretty simple fix. It does not require legislative moves. It just requires us to talk to CPS about this and them to be in agreement with which they are. What we'd like to see is that CPS remove the requirement for psychological assessment to determine therapeutic and non-therapeutic and replace it with evidence-based, standardized assessment tool that can be given by a master's level professional. We have many more master's level mental health professionals available that would remove the PhD backlog. It would also allow CPS to make rulings about therapeutic versus non-therapeutic faster. We've discussed this with CPS, they're on board with it, so I don't anticipate there are any issues moving forward other than we need to determine what assessment tool they want to use for this work.
Jamie, one thing that I didn't hear you say, and you might have, is because the classification is tied to funding and services, we also recommend that a neutral party conduct the assessments to avoid issues related to conflict of interest. If you said that, I didn't hear you say it. But that.
I did say it, but thank you for reminding me. Yes, that's an important recommendation. We'd like a neutral party to do these assessments. It doesn't have a connection to the outcome, specifically a financial connection to the outcome.
And with that, we don't have anything further. We think that this would address the problem. Like Jamie said, we've talked with CPS, we've talked with representatives from the Department of Mental Health, and think that this would help alleviate some of the shortage of folks, as well at the same time making sure our children are protected and treated appropriately.
And CPS and mental health are both in agreement?
The representatives that were there were in agreement.
Yes, ma'am, we've talked about that, and where we're at with it is we're in complete agreement. This will certainly facilitate our work on this end as well. We're talking with several of the providers, including Jamie and some of the other providers in MACA, as well as some from mental health, to really investigate what the right tool would be, which assessment tool should be used so we can standardize that. But should not be any issue at all to move forward with that. The only, not a specific issue with that, but the only other place psychologicals comes into play that still may cause some issue for us are a lot of acute care facilities require that psychological before they will admit. Now, most do that psychological as part of it, but a full psych, I say most, some require that before they will admit, but the general, as far as making a therapeutic ruling or non-therapeutic, a standard tool is by far the best way to go, and we absolutely concur with that.
What assessment tools are you considering?
Two that we have talked about so far, and please don't ask me what the letters stand for, but Jamie can probably tell us. CANS and CAFAS are two of the popular ones that are used out there. We currently use CAFAS as we're preparing to stand up the QRTP as part of the Families First Prevention Services Act. I think it's a little bit more in-depth tool, and it's really just to determine which would best measure that and provide the best justification for the therapeutic ruling. Jamie, are there other tools that you?
Well, it's really yet to be determined, and that's why we need to have further conversations about it. When I first discussed this with our subcommittee, I wasn't thinking of just one assessment tool. Of course, I'm open to that.
Combination.
I was thinking more of a universal kind of in-session protocol that master's level mental health people would use, similar to what's going on now at a psychological PhD level. Nothing that the PhDs are giving our kids, the assessments that are giving our kids, can't be completed by master's level. They're not giving a PhD level MMPI or anything like that. And so when I was thinking of it originally, then when we spoke to CPS, they said they would really just like it simplified into one complete tool. And so that hasn't been determined yet, but there's plenty out there. The Department of Mental Health is using the DLA 20, and I know CPS is using CAFAS. Department of Mental Health used to use CAFAS, and they moved to the DLA 20 now. So I'm optimistic that a tool can be found.
Absolutely.
Okay.
Could I interject something? I think that's a great idea. One of the problems that we saw very early on in Harrison County, I know it is a problem not just in Mississippi but across the country, is getting these children assessed and getting them plugged into the services that they need in a timely fashion. You talk about the backlog of wait time to get in to see the psychologist or whatever. That's very, very good. And one of the things that my staff and I have done to try to eliminate that barrier, I'm one of those people, when we started Rescue 100, we looked around the country to see what worked in terms of boosting foster parents, and we implemented that same model here in Harrison County. With respect to assessments and getting kids plugged into the services they need, we took a trip to Calcasieu Parish, Louisiana. They had a JDAI model site, detention facility over there, and I wanted to see what it was like and how it runs and so on and so forth. And outside the detention facility, they had a small building that had a sign out front that said MARC. And I asked the folks, I said, what is that building? And they said, that's our multi-agency resource center. And I said, well, tell me about that. And they said, a child can go there, be referred from a teacher or a parent or a court or DY, it doesn't make a difference. They can be referred from anybody. They can walk through the door and they can go through an assessment. And depending on how you answer the questions in that assessment, it may trigger other assessments that need to be looked at and go into a little bit deeper. At the conclusion of that assessment, it can take anywhere from 15 to 45 minutes, depending on how they answer the questions. But at the conclusion, you get basically a one-page report that provides this is what this child needs in terms of substance abuse treatment or suicidal ideation or what mental health, whatever it may be. And so I brought that back and we kind of roundtabled it, brainstormed it, and we have established, we didn't call it a MARC, but we established what we're calling a RAC, and it's our Resource and Assessment Center. And I'm going to make referrals there. I think we're primarily going to start with delinquency and eventually open it up to all kids in CPS custody. But they will go in, and it's a computer-based tool that we, over a period of many months, have worked on choices. And they basically created the first assessment, which is like 25 or 30 questions. And depending on how they answer those questions, it may trigger other assessments to be conducted. And the beauty of this is that you walk in from the very beginning, you get the assessment done, and then right there on the spot, we have partnerships with all the providers in the community, and we can make them an appointment right then and there. And so they get plugged, they get assessed, we determine what's needed, and they get plugged into those services immediately. We are hoping that in the next couple of weeks, our county's legal will have reviewed the MOU that we had prepared and sign off on it, and we can get that off the ground. The person that will be doing the assessments is someone from Choices. Originally, what we wanted to do was hire some people to come in, get them trained on these assessments and how to conduct them, and then have them do the assessments. That didn't work out, so what we had done is chosen to go with Choices and have them do the assessments and then provide that information to the court. I absolutely love the idea of, like you're talking about, having assessed and to have it be done by someone not on that clinical or that PhD level. So just food for thought.
I would just add to that counties that have a full-time judge and have a community that are vested are looking at lots of alternatives and different ways to bring resources. And I would say every child in Mississippi deserves those kind of resources. I'm ready to move on to number 4 if you are.
Yes, Justice Bean.
Okay. Now this one, how do you eat an elephant? One bite at a time, but this one is like way more than a mouthful. Number 4, review the diagnostic and evaluation shelters, whether the number is sufficient and whether children are staying in these facilities too long before placement. And Jamie is going to help me with this answer, and Samantha has also worked hard on this. But I think that one thing that our citizens need to know is that we have 57 beds in Mississippi for kids that have major mental health needs that need to be in a facility. Usually it's, when is somebody going to get out so we can put somebody in? To me, one of the saddest things is that at any given time, we have between 10 and 20 or 25 kids that are actually staying in hotel rooms in Mississippi and being cared for by a provider, just a caregiver, not anyone with any specific skills. And the reason for that is because we lack facilities to put them in. We lack resources to adequately address them. For many years, it seemed like we had an argument between CPS and DHS where the CPS would say, well, this is a conduct problem, this is a behavioral issue, and he needs to be in a training facility or a detention facility. And then the DHS Youth Services would say, no, this is a mental health problem, and so it is a CPS problem. I would say that my experience has been that DHS and CPS are on the same page at this point, that we have a problem, and it's a Mississippi problem. As judges, about 3 years ago, we met with judges in Louisiana and Alabama to say, what are y'all doing with these hard-to-place youth? And they were facing some of the same challenges, but this is a can that has been kicked down the road for too long. It's waiting for trouble to happen. When a youth it's just nowhere for any child to be in a hotel room. And you have risk of human trafficking, because oftentimes these are kids with significant mental health and behavioral issues. And so it's something that needs to be addressed. Jamie's going to talk about it, but we don't have a game plan today. What we do is have a route to look at how we can bring all the people together to address this. But these are Mississippi kids with mental health problems, and they really need all of our attention. Jamie?
Thank you. So at the very core of this, I think we have an issue between what CPS needs and what the current emergency shelters are prepared to provide. And there's a big gap there. And that's, I think, what led to this question initially. The good news is we have currently 2 RFQs on the CPS website right now to help address the situation specifically, to address those harder to place kids that come from harder places that are in hotel rooms. So we've got 2. One is the adolescent diversion unit that came out first. And that one closes August the 18th, so we'll know more about the adolescent diversion units after the 18th to see what organizations fit in for those and what that landscape will look like moving forward. Adolescent diversion units are shorter-term placements, emergency placements for those kids that are currently in hotel rooms. Perhaps Dave can speak to this, but when I read the RFQ, that's how I read it. And that would hopefully eliminate the need for the hotel rooms. The second one that came out, they're called PAC centers. That one just came out recently. PAC stands for Permanency Assessment Centers. We currently have one in Methodist. Methodist, I believe Methodist is trying to open a second. And now there is an RFQ so that other providers can also get into this work. It just opened on August the 10th, and it doesn't close until September the 8th. So we'll see, early September, how the landscape moving forward is going to be for PAC centers. But both of those RFQs are set to address the question that we had at hand about what right now that the emergency shelters are not prepared to do. So, and when I say emergency shelters, that in your packet, it was called diagnostic and assessment shelters or something similar. That in foster care terms right now, those are the emergency shelters that Justice Dean referenced. We have 5 around the state, 57 beds total. So the problem is less about the 45-day, are our kids staying there longer than 45 days or not? That's not a huge issue. The big issue is we have empty beds in those shelters. CPS needs those beds filled with these tough kids, and the shelters are saying, no, we can't provide services at that level. And so these RFPs are an answer to that, hopefully. So moving forward, we've got to do a couple of things. One, we have to see what the landscape is like after these RFQs close. Hopefully, wonderful providers put in more and win the bids, and we can move forward and have placement for these kids that are currently in hotels. And then the second, the second component, I can't remember now what I was about to show. The good news is that, we need to do a review of research. And so we'd like the opportunity to take another 3 or 4 weeks to do a review of research, meet with CPS, and probably the Department of Mental Health as well, because remember, the Department of Mental Health, they have services available too, that we need to make sure that we're all, that we're all talking.
If I could add,
All the services.
Jamie, one thing that I didn't hear you mention is that these kids that we're talking about that don't have a place, that are staying in these hotels, the providers that we do have do not want them, will not allow them to come to their facility. Some of them have been in their facility and have caused destruction. I'm reminded of Michael Jackson's "One Bad Apple Don't Spoil a Whole Bunch of Girls." Well, I'm told in mental health, if you've got one child that is disruptive, they can disrupt the entire facility. And so, we want all of our children to be able to have treatment, but I can understand that these facilities are hesitant if it's going to disrupt the facility. So that is one big challenge in this. Is that right, Jamie? I don't want to misstate that.
The referrals that we started receiving were very therapeutic. They're therapeutic group, and they became severe. We decided as an organization we couldn't guarantee the safety with roommates. So we went down to a policy of no roommates, which cut our number of clients we consider from 10 to 5, which also then cut into our per diem rate. So I had to go out and figure out financial thing for that. But it was in the best interest of the youth. The children and youth that we're receiving, they come from very hard places, and we have to not only take into consideration the youth we're bringing in, but we have to take into consideration the 4 youth we already have in the home that are making progress and stabilized. So if we've got a home full of sexual assault victims, and then we're about to put an aggressor, a sexual aggressor in the home, those are the kind of things that we have to take into consideration, not just what's coming into the home, but the therapeutic value after they arrive. And those decisions, our kids are just referrals that the providers are receiving are more and more therapeutic. And it's also a very expensive level of care. So we went, the Southern Christian example I gave you, we went from a ratio of 10 kids and 2 staff. We were 1 to 5 on youth to staff ratio for years, and that is CPS and Department of Mental Health standards. But we as an agency voluntarily went down to 2 staff to 5 kids. So our staffing numbers did not go down, but the amount of youth that that we received, and then that followed the amount of per diem rate we were receiving funding went down. So it's a very expensive level of care, and these children and youth, they're very, very therapeutic. It's very sad.
It is.
But what we have to do is create an environment where more mental health and social services providers can come to the table and fundraise and do this work. So,
Yes, this is,
I CPS groups, they're on board with this.
this is a very
Two RFQs.
important issue, and I want to thank you, Mrs. Himes, for reporting on this, Justice Beam, the whole subcommittee. I can recall as I was sitting here listening to Mrs. Himes give her report, and I was just thinking about when we've been on the House floor, there have been a few questions that members have posed about this very issue, and I'm sure that there have been questions about this in the Senate as well. So I'm happy to hear about the RFQs, and I think that's a very good plan of action, Justice Beam, that you and the subcommittee have to just see what happens after the 18th. Is that the date that you said, August the 18th, correct?
August 18th is when the adolescent conversion units, that RFQ closes, and then September the 8th is when the permanency assessment centers close. And the permanency assessment centers are longer term, they're more like 45 to 60 days. And the adolescent conversion units, from my understanding, are shorter term, hopefully. So I think we need to wait, and we also need to do a review of research, talk to CPS and Department of Mental Health, see what other states are doing. And then we have to figure out creative ways to get this work funded. It's expensive work.
It's very expensive work. And,
It's important.
well, it's for our children, so it's worth it, definitely.
So hopefully, later on, we'll have more specific requirements, recommendations.
Madam Chairwoman, I was nodding my head, and Jamie probably can't see me on the big camera, but yes, that is the intent is the adolescent diversion units would be a shorter term, 30 to 45 days or less, and the PAC centers, 45 days or more intense therapy, but I can't say it any better than Jamie did. This is a group of kiddos across the state that absolutely exists, that I'm afraid for a long time none of us wanted to admit that existed, that we just don't have the resources to house right now. And as Justice Beam said, we have, there were 14 children in a hotel last night. And the problem there is they have a CNA nurse, it's a babysitting, basically, that prevents them from doing anything damaging to themselves or others or the community, hopefully, but they're not receiving any treatment toward their therapeutic needs when that occurs. We've got to have the bed space to put them where they can really get the treatment. So we are absolutely on board and super excited that this is coming to the committee, because this is a game changer for it. While it is a small group of children, it is a very expensive and in both times and resources to care for this small group of kiddos that we've got to figure out.
Very well said. We do have to figure it out. So I look forward to Justice Beam, you and the subcommittee just reporting back to the full task force on what your recommendations are, or if it's just an update, whatever information that you have for us, because it's such a very important issue.
Thank you. We appreciate the cooperation of CPS and mental health, and we probably need to involve DHS in it as well. We did not this last time, but it's just a complex issue, but we owe it to our kids to get it right.
Well, thank you for the report, Justice Beam, from Subcommittee Number 1. I did have one last question that I thought about as you were presenting item number 3, well, after when you were about to present number 4. This regards the expansion of county courts to regional courts. How In what manner or what role would referees play, if any, with the expansion of the county courts to regionals? What would that interplay look like?
I think, and I know this has been on the table for many, many years, and the Children's Justice Commission has looked at this. Certainly, there's something to be said to have local folks handling cases, but the idea would be that we would not have referees that would handle cases at the local level, that county or regional judge would travel the circuit and do that. So if we needed a shelter hearing, that he would be that person. We would also, we have really worked hard on parent representation, and now our larger counties, for the most part, are covered with parent representation. But if you had regional courts, you would still have local lawyers, however that would be done, that would be that county court regional judge. You would have parent reps that would be there. You would have ideally the same guardian ad litem that would travel the circuit, so that you, in the long run, hopefully you would reduce the cost of the court. But beyond that, when you talk about kids in custody and being able to turn them to permanency faster, there is an economic win and a human win all the way around. Is that helpful?
It answers the question, but it also raises some additional concerns and questions that I think that we probably can address, because I think we did have another subcommittee to look at that. So it does raise some additional concerns and questions, yes, it does. But we can discuss it further.
We were just looking at it from the best interest of the child and the parents.
Well, you have done a very great job, as always, Justice Beam, in chairing the subcommittee in your presentation today. I want to thank all of the subcommittee members who served on this subcommittee for your participation, for the work product. Thank Mrs. Himes also. She did a great job in explaining the issues that you had tasked her with to present to the full task force, and so thank you. If there are no further questions of Justice Beam, pardon me, let me ask counsel, do I need a motion for that?
No, but to receive the report, we don't need one.
Okay, I wanted to check with counsel to make sure that we didn't need a motion. What I would just state is that we'll receive subcommittee number 1's report to take it under advisement. We still have subcommittees number 2 and 3 that need to present. And so after subcommittee number 2 and subcommittee number 3 present, then what we'll do is prioritize all the recommendations from subcommittee number 1, subcommittee number 2, subcommittee number 3, and then that will comprise our December report. So we will receive the report of subcommittee number 1, and then we'll take that under advisement and prioritize the recommendations from all 3 at the end. And then we can vote to see what goes in the final report as a full task force. All right, so the next item that we have on the agenda, we're going to go back to the approval of the minutes. Everyone on Zoom, have you had an opportunity did you receive the minutes? Yes, I see Judge Dickinson with a thumbs up and Ms. Baumgartner nodding. Everybody has the minutes on Zoom. Are there any questions about the amendments? If not, I'll entertain a motion.
Motion.
There is a motion. There is a second. All those in favor of approving the minutes from the task force meeting of July 25th, 2023, say aye. Aye. Are there any opposed? Seeing none, the minutes are adopted. We need to schedule our next meeting, and I know that we have two subcommittees who said that they wanted to meet this afternoon after adjournment. Judge Kilgore and also Judge Pierce. Those two subcommittee chairs, if you're on their committee after adjournment, they would like to have a brief meeting. And so we need to schedule the date for the next meeting, and then subcommittee number 2 can present their report at the next meeting. So are there any suggestions for our next meeting date?
I did look at Commissioner Sanders because I'll keep volunteering her for stuff if she's not here, like doing the minutes. But September 26th is a Tuesday next month that she's certainly available. So I'd just like to throw that out there. I don't know if it works for everybody, but and if not, you'll be stuck with me and I'll volunteer for something else. So.
Does anyone have a conflict with September the 26th?
Oh, he was presenting, we need him.
Well, if you're presenting, we need you here. So what? Subcommittee number 2 is next, and so we would need you here to present. So is there another date that's good? What about the 12th?
But he said he can do the 19th.
I believe I have a conflict on the 19th, but I can participate possibly via Zoom. Chairman Wiggins, do you have a conflict on the 19th?
That week, looking at my calendar, I do. The 12th is good. The 26th is good.
Not Thursday. Do a Thursday?
What did he say his other date was?
I have a conflict on the 21st. What about the 13th? It's not on a Tuesday, but is that a good date? Oh, wait a minute, you're in trial, so, correct? Okay.
The youth court judges conference is the 13th, 14th, and 15th.
13th to the 15th, yeah, that's out.
What about the 18th? The life of a judge. I'm good for the 28th. Is that good date? Is that date good? September the 28th at 1? Is that good for everyone? We'll make sure that it's available for you, Justice Beam. All right, so we're going to schedule our next meeting, September the 28th, room 113 at 1 o'clock p.m. And Judge Kilgore, as chair of Subcommittee 2, will present. And lastly, it's not on the agenda, but Judge Dickinson did email Chairman Wiggins and I last month about an event that he is having on the coast. And in reading the email, I thought that it's a spectacular event. And I wanted to give Judge Dickinson the opportunity to tell the full task force about it and also to invite us to participate. So I'm going to recognize Judge Dickinson.
Sure, thank you. So in addition to preside over the youth court in Harrison County, I also preside over a family intervention court which is in plain English a drug court for our protection cases and parents who have substance use disorder. And also have a juvenile intervention court, which coincides with our delinquency cases and our kids who have a substance use disorder. The family intervention court, we have really, really vamped up. This is when I mentioned the grant earlier. That is the court that we got the grant. And every 2 weeks, I have the opportunity to see these families because they're in my family intervention court. I keep up with their progress. My team checks in daily. And every so often, we get to the point where we are able to graduate parents from the court. And that is the day that they get custody of their children back. They've been with us, depending on how the situation goes, maybe a year, maybe a year and a half. And we become intimately familiar with their situation, the hurdles, the barriers, the struggles, the victories, and the successes that they see. On August 31st at 9:30 in the morning, we will be having a graduation. As it stands right now, there are going to be 3 participants to graduate, but you all are more than welcome to sit in under confidentiality. Obviously, everything in the court is confidential. But you can sit in them via Zoom, and I can send out that Zoom link. We have that capability in our courtroom for every hearing. And during the ceremony, it's going to be basically a court. During the ceremony, you'll get to hear the entire story, a summary of the entire story, beginning to end, for each of these parents that are graduating. And I'm also, if they want to, I know Senator Wiggins has agreed to say a few words of encouragement. Representative Copperhead, if you would like to also say a few words of encouragement, I would certainly welcome that. But I just thought it might be very beneficial to this task force for you guys to see firsthand one of the better sides of the things that we experience in youth court. And so that offer is out there. You guys are more than welcome to join us. Typically, with 3 participants, you're probably looking at somewhere between an hour to an hour and a half. So it wouldn't be much of your time, but that invitation is out there, and you guys are welcome to join us.
Thank you so much, Judge Dickinson, for making that invitation available to us. Thank you so much. Are there any other announcements, any other business that we need to dispose of prior to receiving the motion to rise and report progress? Seeing none, I'll entertain a motion to rise and report.
So moved.
Second.
All those in favor say aye. Aye. Are there any opposed? Thank you so much.
Thank you.
Judge Pierce, I have a question.
Yes.
Was it the meeting, is there going to be a separate Zoom link, or how would I be able to jump in on that, or me and Dave jump in on that?
I don't have a Zoom link. I was going to ask Professor Calder if he could do one for us.
Or they would use
What
this one.
email?
Can we not use this one?
Did y'all want to use that one?
Can we use
If
this
we
one?
can use this one, that'd be great.
Yeah, why don't you just use this one?
Okay.
Yeah, we can leave it open. I'll just tell it we'll go there.
I know we probably emailed. I didn't get your name until earlier when you said it, so it's nice to meet you.
I did. Yeah, they are 12 and 13, 12 and 14. And they were 6 and 8 when we got them. We actually had a good experience, so I don't want to, I'm very involved in that community, and so I hear all the horror stories,